Hey, Brian Parker, another exciting video for you. This one is a good one. I tell you what, I don't like to lose anything. I don't know if that's good or bad, but as far as my clients are concerned, that's good. So when I do, if the judge is really good or I respect him or her, and I can see that there's a careful, detailed analysis, I'm still not gonna like it, but I'm thinking twice about appealing. Now the opposite of that. I've got a case that I had where the judge I hit it from every side, everything I could, just to show how bad LVNV funding had done, how bad a job they'd done on proving my client owed a debt that he clearly didn't from their own paperwork. So this is the actual argument of the LVNV attorney. Shazam, I'm going to read it. I believe this is going to sound very similar to the last case. It's a standard collection matter. I believe the documentation has been submitted and we would rest on the pleadings, Your Honor. That was their argument. I went, as far as the transcript is concerned, if you look at the transcript, I'll attach it to this video. I went about 7 pages, just hit it from every angle. It was quite clear that my client didn't own the debt. So the judge said, Parker, you win, right? No. Shazam. So here's the LVNV funding's attorney's response. Very briefly, Ron, I don't know how much more briefer he can get than his beginning. He wants to say an account is not a debt. A debt is not an account. A signature isn't authorized, but what makes it authorized? It's an absurd argument. It's all smoke and mirrors. That's it. So the court's going to see that and go, well, clearly Parker knows his stuff, and that's what the court didn't say. But this drove me crazy. Okay, at this point, as opposed to any other point, the court is satisfied that the plaintiff has proved the debt, has provided the information, that the arguments are really a lot of semantics. He started off by saying, yeah, it seems to be a lot of semantics. I guess facts and law are not semantics. So I got pissed and I appealed. The video that I'm doing today is, congratulations, Parker. You won another appeal at a circuit court, dumping a district court that didn't want to put the time in to these cases. And this is the most beautiful thing you want to see on the court docket. Shazam. And it says, oral arguments placed on the record. That was done at the circuit court last week. Court orders that the judgment of the district court, that's the guy, Mr. Semantics, is vacated. The order granting summary disposition in favor of plaintiff is reversed, and this matter is remanded for further proceedings, courts to submit an opinion in order. If I get that before this video publishes, I'll add the opinion order. It's going to be a doozy. I mean, that stuff makes me so mad. You can clearly see the judge didn't put the time into it, and the attorney just phoned it in, literally. So what are we going to attach? What am I going to show you today? So this is an LV funding brief. So I'm the appellant. I'm arguing against this summary disposition, and the appellee is LVNV funding. So attach this. I'll have my client's brief. I'll have LVNV funding's appeal brief. The answer to LVNV's complaint, that'll be important. You'll see when I show you their complaint. The counter affidavit, I always insist that you add to your answer. The show notes, and I'll add the transcripts, not too long, of the hearing where the district court ruled against me. You got to read this thing. I mean, I left it all on field, as they say in sports terms, and apparently there's a lot of semantics. So that'll be on killdebt.com. All those documents I just mentioned. I want to show you 5 things to attack both the judge, but mainly LVNV funding's ruling in its favor. And the first thing you do is you look at the creditor and who or what they gave it to. So here is the bill of sale and assignment of this Citibank debt. Shazam. And that's your basic. Everybody's seen one of those if you've done any Citibank cases. It's the Brandy Reardon, and she's signing. By the way, there's no date. So when did this happen? And that's significant in Michigan, by the way, in some states. She claims to be an authorized party. Who says this? So let's take a look at this thing. It's based upon, in that second paragraph. So let's just focus on the second paragraph. Shazam, paragraph. It's based upon the master purchase and sale agreement. There is nothing attached, but it's based upon it. It's between a buyer and a seller. In this case, it's Citibank and Resurgent. And they claim that the accounts are attached to Exhibit 2 in the final electronic file. There aren't any. It wasn't attached. So you clearly have somebody signing something claiming to be authorized with no proof. Significantly, there's no date. Why is that significant? Because in Michigan and some states, I'll show you exactly why it's significant. Shazam. Case law in Michigan, an assignment is defined as a transfer or making over to another of the whole of any property, real or personal, in possession or in action of any state. To constitute a valid assignment, there must be a perfected transaction between the parties, which is, here we go, which is intended to vest in the assignee, that would be LVNV funding, a present right in the thing assigned. So let's put up that bill of sale again, Shazam. If this is undated, when was the debt? By the way, there is no debt of my client in this. And as I said, Exhibit 2 and final electronic file wasn't attached. So not only is my client's name, account number not in this bill in the sale of assignment, for it to qualify as an assignment, it should say it's transferring said account on a certain date. So then they have a present right. They can't report that something happened at some time in the past. It has to have a present right. So under Michigan law, Court of Appeals, it hasn't been overturned. This is not a sound chain of title. Right from the get-go, from an unauthorized person on an undated bill of sale and assignment. So number 2, we look at unauthorized signatures in the chain of title. So in this case, Brandy Reardon for Citibank with no proof of signed with no proof of agency, violating Michigan case law. Number 3, Shazam, cut and paste signatures. Those are fun. I've looked at the transfer and assignment document. That if you have an LVNV funding case, you probably have these in your complaint, so check it out. So let's put up a couple. Shazam. And then let me put next to that, the next page, Shazam. And you can probably see what I see. It's your opinion, my opinion, that those are the same signatures on different days on different documents. So whatever covers your state's proof of credibility and reliability for signatures that are just cut and paste, in my opinion, you must look at the law and see if they can do this. I'm pretty sure you've got to have some kind of authority. For example, they claim to be the authorized representatives, but who says? There has to be something saying that that's the case. And if they're the same signatures on different days, which one is the actual real document that was signed that they're using? They get away with this? Okay. So 4, this is a very common thing that LV funding does. They'll file a lawsuit against my client, and as we know, 9 times out of 10, it's going to get defaulted, or they'll call the law firm for a quick but bad settlement. Because 9 times out of 10, again, it's going to get defaulted. But when you come in with really good arguments or with an attorney, up pops an affidavit that wasn't there claiming to prove everything. So they literally just, in my opinion, look at what you argue and then drop it into an affidavit. It's not good. I'll tell you why it's not good. Not good as in, shoot. It's not good in that it's signed after the litigation started. So already it's hearsay without exception. But most affidavits come in under what's called, and we've gone over this in videos, the 803.6 exception, which is the business records exception. And there has to be personal knowledge of every part of the chain of title, and you've got to work at a certain place. You've got to be trained at in this case, Citibank, to claim that those records are sound or have some personal knowledge of this. Nothing, let me put up the two parts of the one page. Shazam, I've got dogs and cats around me again. So you got to look at the information in the affidavit, and the second page, I've highlighted that the attached records were executed in number 3 via electronic signature. So she's saying, yeah, those signatures are fine. She wasn't there. Number 2, she never attached the documents. And the attached records were kept in the course of Resurgence and LVN Funding's regularly conducted business. They didn't attach anything. They didn't attach the master service agreement. So this person is signing something that is not clearing the 803 business record exception, and she's signing it after the litigation. It's called hearsay within hearsay, and it's not right. But the judge, the district court judge, looks good to me. Anyway, so then we have 5. Here's their complaint, Shazam. 2 things to notice in their complaint. My client's name is not there. I didn't have to take the white out. Or they put a complaint out. This is what they did with no name. They just put defendant. And if you look at number 2, plaintiff is either the original creditor or the assignee of defendant's account. Well, LVNV Funding has never been an original creditor for anybody. They don't put out credit cards or loans. They just buy up stuff. So under Michigan law, I think I've got it here. There's a specific statute that says MCR 2.112N, look for your equivalent in your state, says you've got to say who the original creditor is if you're going to make those kind of claims. In a collection case, also, you got to have the name of the person, not just defendant. They will say, well, it's in the caption. From the complaint on down to the signature, the name of my client is not mentioned. So I'm going to give you some arguments that you can use, whether it's in court, like at the district level, I got another cat now, at the district court level that I appealed, or at the circuit court level. Let's put some arguments up for you. Shazam. You know, I always have you do that preliminary statement in every answer, right? And I'll be attaching the answer to this case. Argue that. It's the most powerful part. Those first 3 sentences, you want to start when you've got the judge's attention as premium as it's going to be, because a couple of minutes later, they're going to be dazed over. So use your preliminary statement that you create from your counter affidavit, and it's in your answer. Number 2, then provide the legal framework that either supports your position or says they didn't follow the law. In this case, they didn't follow the case law, meaning you have to show a present right to assign a debt if you're going to be part of the chain of title. Number 3, evidentiary gaps. That attack you make on their affidavit, that's an evidentiary gap. Citibank is claiming to sell to Resurgent, who then claims to sell to LVNV Funding, but we've discovered and we've shown that under Michigan law, most law, Brandy Reardon is not authorized to assign anything, and they didn't attach to the actual assignment what they were assigning, and my client or you is not inside that. So that's an evidentiary gap. It's called a busted chain of title. So you look at the standard review and burden. Every appeal says, here's the standard law that you have to look through for a qualify to get an appeal. And I always just go, yeah, I'm going to go with what they said, because it's all the same and it gives you more space because you have a limited amount of pages to make your argument. You rebut any anticipated arguments they have. They're all the same. They weren't any good at district court. They weren't any good at circuit court. You give the court its remedy and policy. Your Honor, This happened at district court. You can see that I overwhelmingly proved that there is a material issue as far as ownership. The remedy is reverse this and send it back to district court so I can have my comeuppance, so I can get my client his day in court. There's going to be a rebuttal, so here's some zingers for you. Shazam. Just incorporate in your preliminary opening statement, if you will. Your Honors, redaction is not authentication, because they supply stuff where there's tons of redaction and go, yeah, that's his debt, that's his name, and it's all redacted, it's a mess. So redaction is not authentication. 2, an affidavit cannot bootstrap its own hearsay. Remember I talked about hearsay within hearsay? The affidavit they supplied after the complaint was started, litigation was started, is hearsay. Then they depended on more hearsay to prove the own hearsay, and that's what they do. They think they can get away with this stuff. And the circuit court that we won at cited all this stuff. They hadn't proved their case. Intent to assign is irrelevant when you can't prove what was assigned or who signed for the assigner. Bingo, Brandy Reardon and those other signatures. And then number 4, LVNV's own cases read like a manual on why they lose. So oftentimes, a lot of attorneys do this. They'll cite your cases and go, this weird footnote over here means we win. Or they'll just cite cases because they take no care in this stuff that help you. So you point that out. So my final argument was because LVNV offered no authorized debtor-specific assignment and no competent witness, it lacks standing. Every case I do is a standing case. As a matter of law, the district court's ruling should be reversed and judgment entered for my client, or at a minimum, the case remanded for discovery. I said, at this case, he went straight into the summary disposition before we'd done any discovery or anything. A lot of these judges just want this stuff. They think, well, he owes the debt, as opposed to who owns the debt. They don't want to know from that. So again, attached to killdebt.com will be the following: my client's appeal brief, LVNV Funding's appeal brief, the answer to LVNV's complaint at district court, the counter affidavit against LVNV, the show notes, and that transcript. It's like 10 pages of the district judge, of me laying down everything you need to say, whatever state you're in, and why we should win. And the judge going, yeah, it's semantics. Still don't know what that means. But he's going to know what it means because I'm going to see him again. Now, I've mentioned this before. When I win an appeal, I'm now sent back down to appear in front of the judge that did the bad stuff. And you see all the gray hair? That is supposed to make me mature and not want to go to the judge, how you like me now? This may be one where I don't say exactly like that, and I've got to be respectful, but I'm an attorney. I know how to play with words. This may be that one of a kind where I go, I've got to say something. Because it was so bad, semantic, or come up with some fancy line about semantics. I don't know. Anyway, speaking of good stuff and maturity, this site, killdebt.com, is maturing into killdebt.ai. Not into that, but there's going to be a large platform now where you could say, oh, I got to do an appeal brief. Boop, 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 boop. Up pops an appeal brief for you. I got to do an answer. Boop, boop, boop. It's not going to make that sound, but they're going to take 1,200 documents that I've created over the years, and all those letters and everything I've ever done, answers, briefs, appeals, summary motions, discovery, and put it into an AI. So you just put your information, up pops the document you need. And we're looking for probably 50 people that are members currently to volunteer to play with it and tell us where we need to improve or how we're doing, what's important to you, what we missed. And that, we hope, will be starting June 15th. So if you remember June 15th of killdebt.com, you're going to get free killdebt.ai. and you may need this in a pinch. You've got an answer due tomorrow. There's KillDebt.ai doing all the work for you, speeding things up. Just apply your state, and facts. So look for that mid-June 15, because it'll be the invention of Parker GPT. Woohoo, hear that airplane. So look for Parker, I don't know if it's going to be called that, Parker GPT, on the new platform, KillDebt.ai. I hope you enjoyed us getting LVNV funding. It was fun for me. Thank you very much. I hope this was fun for you. Bye-bye now.